You ready?
Yes, Judge, does he need to be brought out or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair, right? Because it's his case, so.
You didn't hear me.
It's only fair because it's his case, so we might as well bring it
No.
up.
He asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
Okay,
That's my client.
he must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
Okay. Ms. Beck? Is it Celine Beck?
Yes, Judge.
Okay. Oh, yeah, I haven't seen her in a long time. Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle and the defendant due to him pulling away. The officer began to roll around on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
So, Your Honor, in this case, to read the full dim, it was a disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then.
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and.
Didn't say that.
That was in the complete dims, Your Honor. And then it
Did you know
says,
about that?
and
Yes,
aggressive
Judge,
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey,
So-
I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So.
Criminal trespass.
So they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving.
Right.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only,
Right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and
He leaves.
he only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
What, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
Did we ended up revoking the bond on this, right?
Right, so when he called, Ramona asked him to vote for today.
You were Mr. Jefferson. Mr. Jefferson, you're charged with 2 cases. You're charged with harassment. You're also charged with terroristic threat of a family or household member. On the terroristic threat, you're facing up to a year in jail and or a $4,000 fine. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Oh, on which one, Your Honor?
Are they one and the same?
They're not out of the same transaction, Your Honor.
Okay. I guess start on the harassment, which is the earlier one.
Yes, Judge. On October 15th, 2024, the officer met with a complainant at her residence in Harris County, Texas regarding a terroristic threat call. The complainant advised the defendant is her ex-boyfriend, who she was living with until April 2024, when she decided to move out. The complainant stated she received a photo of the defendant with a firearm to his head, and after the complainant blocked the defendant, she started receiving multiple emails from him asking for half the rent. When the complainant refused, the defendant sent her a message via email saying, "If I lose this place, I have nothing to lose after that, so I'll be sure to put you there, and that I promise." The complainant went to work and she advised the defendant was at her job and refused to leave despite her request and stayed outside in his motor vehicle. And then, would you like to hear?
So the harassment is the text, I'm assuming?
The harassment is the multiple emails, including the message via email saying that the threat.
Okay. All right, go for the terroristic threat. Same complaining witness?
Check, Your Honor. Yes, Judge.
Okay.
So for the terroristic threat on January 2nd, 2025, the officer was dispatched to the residence in Harris County, Texas, in reference to a terroristic threat call. The officer met with the complainant, who stated the defendant messaged her stating she paid her portion of the light bill and the complainant needed to come and pay the other portion. The defendant messaged her twice on TikTok saying the same thing, and the complainant stated via TikTok, if the bill was not paid by the 4th, there will be problems. The complainant received additional messages from a TikTok account with the username account not found, meaning the account was deleted or disabled. And the account stated, "I tried to be respectful. I promise you, if it is not paid, I will put your social security number and personal information on the internet and I will shoot up that house, starting with your bedroom." The complainant stated she is in fear for her life.
Is there any kind of immediacy to this thing? Do the covers back. The stickers. It's no.
Your Honor, he specified that prior that if he's not paid by the 4th, there will be problems. And then he's again repeating that state, if it's not paid, that he will shoot up the house. The threat would be, I will shoot up the house.
There's no contingency in a terroristic threat. It's a threat. Here, you have an act that's contingent on something else, right? That's not, no. All right, so Mr. Jefferson, I'm going to find there's no probable cause on terroristic threat. However, I am going to find that there's probable cause to go forward on harassment. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes.
You are also not to be in possession of weapons. If I find that you become a danger to our community, I have one place for you. I will revoke your bond, put you in jail, no more PR bonds. You missed court yesterday. We issued a warrant. I will reinstate your bond today, but this is the only get out of jail free card you get. You miss court again, I will revoke your bond, no more. Do you understand? It is your responsibility to know when to come to court and when to show up. We have given you a lawyer. It is also your responsibility to stay in touch with the lawyer. If he tells me he can't get hold of you because you're ducking and dodging, likewise, I have one place for you. Do you understand? So can you file no contact, no weapons, please?
Yes, Judge.
On the harassment.
Yes, Judge.
So what we're going to do now is I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Then we'll wait for your lawyer to show up.
Jefferson, the state is asking for his next appearance to be required so they can serve him with a civil protective order out of the 280th. I would ask for his appearance to
How's
be.
that going to work?
Yeah, so Your Honor, in this case, the complainant through our office is applying for a protective order. So we're just asking for his appearance to be required so we can serve him the protective order, and then the civil division will take it from there.
I would object just for inconveniencing him, Judge. And don't they usually just have a deputy come out to your house and serve you?
I don't know. I mean, I've never done the 280th domestic violence where I don't know. I mean,
I've encountered them a few times, but I've never dealt with the process of my clients being served them. They just get served.
so you apply, you've got the hearing, you have to serve him so that way he can go to the hearing in the event that he wants to
And
contest.
that's all we want to do is get the
Right.
process started so we can protect our complainant in the case. And we would have had him served today, Judge. I just don't believe that things have been.
Want me to do a protective order now?
No, because this is the long-term civil protective order, not just the MOA, Your Honor.
And they already have a no contact.
We do, I believe, have a MOA on file.
You want me to
in
put a
case.
MOA in now?
Sorry?
You want me to did I already do a MOA?
Yeah, I thought you did.
I believe we do have a MOA in this, well,
No.
in the prior case we do, in the new case,
No, that wasn't signed.
Let me,
We just-
in one for
yeah,
now,
yes.
because I know that he has the harassment, he has the other terroristic threat. I didn't realize that you guys had filed it.
Judge, he doesn't live with the complainant. They share no children together. He has no problem staying away from her.
Mr. Jefferson, come up. Mr. Jefferson, on your harassment case, I'm entering in what's called a magistrate's order for emergency protection that identifies Ms. Green as a protected individual. As of this day forth, she's now protected, meaning that you cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order in any way, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. Do you understand?
Yes, sir.
So I'm going to have you sign this now. The state's asking me to have you come back so you can be served, but I don't do that in any case. And I don't want to show preferential treatment for you guys, you know, like I would show preferential treatment to them because unless I know that the person is a flight risk or homeless to where we know we're not going to get a hold of them, I normally waive on everybody. And I can't, it wouldn't be fair for me to show preferential treatment to have him
Your
come
Honor,
back,
we
you
just
know?
had to ask.
So will acquiesce in granting a protective order now, but so what I'm going to do is I'm waiving your appearance so that you don't have to come back and waste your time in court here. But you must stay in touch with Mr. Sims. And if he tells me he can't get a hold of you, then I'm going to issue warrant for your arrest. No more PR bonds. Do you understand?
Yes, sir.
So if you start to become a problem out there in the free world, I will take the free world away from you. No more PR bonds. You pick up a new case, no more PR bonds. You start harassing, no more PR bonds. I'm not asking for much. All I want you to do is stay away. There are a gajillion and one fish out there in the sea. It's not throwing your life away. You understand what I mean? Life is way too short to live in a 6x9 box. Jail sucks. It's not fun. All right. I'll have you sign the protective order and then we'll get you guys out of here.
Thank you, Judge.
Thanks.